Welcome to this episode of Chaile Time. Toby, welcome.
Thank you, Tsepo.
How have you been?
Yes, it's been a rough week. This week, I really came to once again understand that labor relations, it's about the interest of people. Whether you're an employer, whether you're an employee, those HR managers who are working for companies with great cultures, they're probably going to crucify me now. No? But the reality of the matter is you can have a great culture. And I've realized this week again. You can have a fantastic culture. But when it comes to dispute resolution, it's about me. That's it. Whether you're an employer, whether you're an employee, it's about your interest. Let me tell a little story. This week, I'm just, once again, it's been 20 years now involved in labor relations, and I'm again just shocked by how people can be so greedy and fighting for their own interest. This company, quite a large company, they've got a marketing executive, and this marketing executive is actually disabled now and incapacitated, have not been working for a year now. Sitting at home for a year. The business manager fought his arms off to get it authorized for them to continue paying this person for a year. They could have dismissed this person a year ago.
So are they still paying him?
It's a her.
Oh.
They paid her for a year. We're talking about just over 2 million rand that they've paid this person. And they had no need or legal reason necessarily to do so. Anyway, they've even helped her to push through the disability policy they've got with the Provident Fund and so forth. They are paying out now. On the medical report, yes, she's disabled, she cannot work. If you ask her, please come back to work, she can't work. She can't even attend to meetings. Anyway, we followed the incapacity process eventually now and gave her an opportunity to make representations. She's disabled. She's enjoying a disability fund now, cover. For the rest of her life. And by the way, the monthly payment I found out is more than what the salary was.
Wow.
Okay, anyway, or more that she got out from the salary. So, this morning we got a 7-Eleven form. She's going to the CCMA. She wants more money.
After she's being paid for the whole year.
She's been paid for a whole
for sitting
year.
at home.
For sitting at home. The company pushed the Provident Fund through. She's getting a disability cover. Medical records, she can't work. If you ask her, come work. We actually did ask her, please, if you can come back to work. She can't work.
But was she now incapacitated at the workplace?
It's not because of the work itself. It's her own medical
condition
or whatever the case may be. But you know what? I spoke to the company's attorney. Her boss was actually seen in his car last night crying because of disappointment. Just the fact that this person is now going to the CCMA. And one of the emails, what is interesting is her conversation with the company and her own legal advice, whatever. She actually asked her own lawyer or whatever the case may be, was she not supposed to get a severance package? And he actually said no. So it seems like the employee's got this thing in her mind that she was supposed to get a package. Now she's going to the CCMA probably to organize some kind of settlement, a package.
Now that explains the me.
It's just me. But employers are the same, make no mistake. But in this case, hey, it's this week we're dealing with an employee. So,
wow.
Oh, but anyway, if I can just balance it out a bit, because now the people will feel, I'm picking on employees now again. Yeah, you see, so I had a meeting yesterday with a company, and this HR manager told me to it. I'm new in the company, and I was told by the CEO, we must get rid of a certain manager now. So I explained to them, look, in terms of what the person did wrong, it probably justifies a warning, but nothing more, you see. So there's no case for dismissal. No. Now.
Make it happen.
Make it happen. So I always laugh and I say, labor law taught me now, a dispute, it's got two legs to it. The law on the one hand and the ball on the other hand. You need to be street smart. Then you start using the game of dispute resolution. You throw the ball at other person, see what they do with it. And if they don't throw the ball back, it's their problem.
Then it's gone.
This is where it comes to the dark arts of labor law, if I can put it this way.
The thorny part of
The thorny part, how to make things go away.
You remind me of my years during COVID 2020 and 2022 February. During that time, that was the slogan: make it happen. I don't want that person, make it happen.
Yes, yeah, so employers are just as devious, Another case, we're going off point now, but anyway, it's just coming to mind. I had another case this week. Okay, it's a legitimate reason. They are restructuring the business, no problem with that, but it's a small-scale retrenchment, Section 189. It will only impact about 4 or 5 people eventually. Actually, no problem whatsoever, but I don't want to follow the consultation process because it must happen now. I don't want to pay them from a week now. Now, look, the thing is this now, when it comes to a small-scale retrenchment, obviously what I'm telling you now is subjected to the actual consultation process. But I normally do it within a week, then it's done. You have a few consultation processes, depending on the proposals, you can extend it and whatever the case may be. But it's normally a quick process. No, too long for them. 1 week is too long. It must be done now. So employers are the same.
But so when you say it must be done now, so you can't give first consultation, you give them an opportunity to go and think of the remedies to avoid dismissal, let them come with their suggestion, those kind of things.
They tell me the owner don't want to pay a new salary or even a few days. It must happen now. So I told him, but listen, what's the owner going to say? If 3-4 months from now, he must reinstate the people and back pay them. Then it's not going to happen. Then it's my fault because I gave wrong advice,
with the current salary.
Yeah, and then
pay with the current salary, not the old.
Yeah, and then I tell them about the Woods case. A few years ago, I think it was a labor appeal court, so there was a Woods case where I think it was 28 workers or something like that who were retrenched in 2012. Now, this case came out recently, a few years ago. So this case has been going way up for probably about 10 years now, okay? And the company consulted on all the proposals made by the union and the employees, except one. And right up to the labor appeal court, the company said, but they didn't understand one proposal. You know what the judge said? No. Reinstate all of them, back pay them for 12 years or 10 years or whatever, and then go back to the drawing board and get understanding of that one proposal. So, because we don't know if the proposal will work or not, but that's not the point of the court case. Go back to the drawing board and see if the proposal is workable or not, and then do whatever you have to do. But when you explain that to the employer, when you explain that to the manager, it's like, I understand. But I have to explain that to your boss.
To the CEO or the big guy, it's a problem.
So labor relations is about the interest. And if you have a great culture, fantastic. But the day you walk into that CCMA, the gloves are off.
Yeah, true.
I know you said the other day we shouldn't always take our gloves off when you go to the CCMA, but yeah.
No, I did actually, but I'll talk about it later. So, yeah, tell me more about your cases. What happened at the bargaining council?
I shouldn't say this because when you're a labor law company like us, we always win. I sometimes I see people applying for a job as a labor law specialist. I've got 100% success rate at the CCMA. Man. And half of those successes now are settlements. Anyway, I lost the case. And I take it quite personal when I lose the case. I lost the arbitration at the bargaining council, and both on procedure and substance, mind you. I really did not expect this. I think this is a case where the ball was thrown at me and it actually knocked me between the head and knocked me out of the I'm just like, I can't believe I lost this case. And the thing is this, and this is what makes labor law difficult, dispute resolution. When it comes to dismissals, from a commissioner's perspective, or a judge at the court, or a chairperson, it's based on the reasonable decision maker test. The reasonable decision maker test really means this. It's not about the right decision or the wrong decision. A commissioner does not have to make the right decision. He must make a reasonable decision. And that is why when I represent clients and say, listen, should we perhaps settle? No, out of the principle of the matter. But they don't You see, taking the glass off, you see. But the thing is this, you are going to go up with a commissioner who only has to make a reasonable decision. Now, if you and I are both commissioners, okay, and there's a case, you may find that the dismissal is too harsh. I may find that it's not too harsh. And both are right. Well, not right really, because the test is not correctness. The test is reasonableness.
Reasonableness.
You know, so, and I've read case laws from the labor court where the judge says, yes, I do not agree with this commissioner, but I suppose it is a way a reasonable person can argue, and then he's fine. That's the challenge. So what happened in this case? This employee stayed away from work for 9 days, end of last year. He did not inform his supervisor, did not apply for leave, nothing, disappeared. We actually sent an SMS to him to say, listen, you have been absent without leave, please report for duty.
So you followed the right protocol.
We followed the right protocol to reach out to the employee. He actually came back to work the very next day, surprisingly. But this is the thing. Apparently, when he came there, he didn't arrive, he didn't pitch up for duty. So he was supposed to be at 8 in the morning, but he didn't. He only pitched up like 12 o'clock. And he came to tell the company he no longer intends working there, because actually what happened here, apparently, is that he impregnated a woman, and now he's afraid for his wife. So he's running away from his wife, and he needs to go to the Eastern Cape. Yeah, I'm telling you who. Ja, krap wel nie, Peter, né? Maar in elk geval, now he's running away, so he doesn't want to work there. Mistake one the company made is by typing out a resignation letter. Please do not type out a resignation letter for your staff who don't want to work there. Give them a piece of paper, give them a pen, let them write self.
Put the signature and put a date.
Yeah.
I actually advised one of our clients to do that because the guy went to drink and he drove, let a friend drive a company car, but I will tell you about it more later.
So that's the one thing. But 2 administrators from the HR department tried to convince him not to go, reminding him of his responsibilities towards his family, his wife, and his kids, and whatever. 2 of them talking to him in his own language. But he was adamant he does not want to be there. So he signed that resignation letter, né? And then he left. Lo and behold, 5 months later, when he filed a unfair dismissal dispute and his condemnation application or whatever the case may be, in that referral, he put in a traditional healer's note that he was actually booked off for the last 5 months sick. That's the first time the employer became aware of, okay, there's now a sick note, but only at the time of when he's filing the dispute. So obviously I argued, just one more thing is, and this is also quite important if you're in HR, when you fill in a UA19 form, if a person resigned, you tick the resignation box, not the dismissal box.
Or retrenched.
In this case, HR accidentally ticked the dismissal box. And I also understand it was an honest mistake, because they say, and I know because it's my client, they always, when it's a dismissal matter, there will always be a hearing. So this is the first time the HR staff actually dealt with this kind of matter where somebody apparently resigned, because normally in the workforce is a very stable workforce. You don't really find people resigning often. So they just tick dismissal because that's what they always do.
Nice culture and everything.
Is that culture, that nice culture, whatever the case may be. Anyway, so we went to arbitration, and I filed my argument was a jurisdictional dispute, disputing the existence of a dismissal, saying there was no dismissal actually, So now the onus is on him to prove that a dismissal existed. You know what was interesting about this case also is never try to read the commissioner, because, we went back there about 2 or 3 times. He was represented by a union official who knows nothing about I suppose he won the bloody case. He didn't know he must have his own evidence. He didn't know he must have his own bundles. So it got postponed so that he can prepare his bundles. Okay. The second time we pitched up, he still didn't have the bundles. Why? Because in his mind, he emailed it to the bargaining council. So they have it. So what's the problem? And I'm sitting there with my bundles, all evidence. And, most of the time, he and the commissioner was just fighting. But anyway, nevertheless.
I think that's also my weakness. I read too much into how the commissioner interacts with the other party, but normally I take a sit back and let them fight amongst each other, and when I get my opportunity I jump in, plant a seed in the commissioner's head and take a sit back and then let them do
and then you think, you got this one in back because they were fighting. Don't read the commissioner. I had cases where the commissioner was against me and we win. Then you have cases where the commissioner is against the other party and then they win. So anyway, they argued the UA19 form. They argued he didn't know what he was signing. Okay, and they argued the company knew about the healer's note because even though it was only submitted at the end, whatever. So the commissioner found us procedurally and substantively unfair, basically for the following reason. Now, I'm not criticizing the commissioner because once again, commissioners has wide discretionary powers how to deal with the matter and is based on a reasonable decision maker test. So the question is, was the way the commissioner argued reasonable or not? That's the thing. We are going to file for a review. And this is my point. Sometimes I feel, and this is just me, okay, that a commissioner can get so engaged in the technicalities of a dispute that they lose common sense, what the basics of this matter is. So the commissioner basically argued that there was a sick note. Okay, so maybe we were supposed to call the person back for a hearing or something in arbitration. I don't know, because that's when the sick note became relevant, or we were advised of there's a sick note, okay? The commissioner felt that the supervisors said that, they did not phone him on the first day of absence, even though the employee did not inform them whatsoever about his whereabouts. On the first day of absence, he did not phone the employee. But he did subsequently on the second or the third day try to extensively get hold of this person. They even phoned family members. They could not be traced whatsoever, okay? And so the commissioner felt that because of the sick note, balance of probabilities. Interesting thing that confused me a bit is that the commissioner said there was no evidence that suggests he wanted to leave. There was a sick note, they should have called a hearing. But we had two witnesses who stated they tried to convince him to stay and he said no. Now, I can't say the commissioner didn't apply his mind to that, but he mentioned it in the arbitration award, but he made no feedback on that aspect of the arbitration. So I'm still like, okay, what's the common sense here? You got a guy who came in and said, I don't want to be here. Two people spend an hour to try to convince you to stay. Yes, they made a mistake. The UA19 form is wrong. Yes, they made a mistake by filling in a resignation on your behalf. I get that. But there are two witnesses. He's got no witnesses whatsoever. So I'm still like, what was supposed to happen here? Now, the labor court's view typically on this matter is if an employee conducts himself in a way that a reasonable person understands that the employer no longer has the intention to continue working, then that's a resignation. So I'm still confused. What was the company supposed to do? And because it was apparently procedurally unfair, he also ruled it must be substantively unfair because the manager did not actually try to get hold of him on the day one. And his explanation is acceptable. He was sick. How can you just end the contract of a person who was sick? So now quickly on review, what are the matters in principle we're looking at? Yes, we obviously look at legal interpretation. Did the commissioner apply his mind to legal principles? From a legislative perspective, that's not typically what we're looking at here. What we're looking at typically is whether the commissioner committed a gross irregularity, which is typically a latent irregularity in terms of how did the commissioner dealt with arguments and evidence presented to him? Did he apply his mind to it? A patent irregularity in terms of that the commissioner followed a fair process, and then whether the outcome of the commissioner, once you take the evidence and the arguments into consideration, whether the outcome is a reasonable conclusion based on the evidence and argument. Was the outcome of the commissioner reasonable? That's basically what we're looking at. So, yeah, most review applications probably fail because there's a sense of finality to arbitration awards, and it's always very risky. You don't know. But yeah, the commissioner ruled a reinstatement with retrospective, with back pay and so forth.
From August.
That's August last year, yeah. But now the thing is still, you know, the question still is, here you have somebody came here, I don't want to work here. There's witnesses to that effect.
But now, that sick note, when is it dated?
That's another thing, the sick note. Now, I had a bit of a demonstration there. That sick note was dated the day before he filed the actual application to the bargaining council. Yeah. So the sick note was only written not by the medical practitioner, by some kind of administrative assistant. I argued hearsay evidence because the sick note didn't say, yes, I'm the doctor or the traditional healer, I saw the guy on this day. It was an admin person somewhere saying the person saw a doctor or a traditional healer on a certain date, and that doctor's note said, or traditional healer note said that, yes, we agree he was booked off for the last 5 months. So I'm like, I'll ask the employee on the cross-examination, if you have flu as an example, explain to me the process when you go to a doctor when they book you off. And he agreed, yeah, you'll go to a doctor, you seek, they do a diagnosis, and they will then book you off for the next 3 days. You don't go to 5 months later and say, yeah, you do agree I was off the last 5 months now. Well, that's what happened.
So what was the comment on that or feedback on that one?
Nothing. I mentioned it. The commission mentioned in the arbitration award that we did mention that. It means nothing. So I'm like, okay.
Tough one, eh?
Hey, but it hurts, man. It's just...
As kiss one.
Luckily, we win most cases. But
no, we do win most cases.
But this one, you know,
and it drags so long.
Unpredictable, you know.
It drags so long because I think I also appeared at some point because there was a recession.
Yeah, there was in limine process with the condemnation.
Yeah. It did drag so long. So is that all?
That's the case for today.
Thank you for watching. Catch us next time. It's Chaile time.
Thank you so much. Next time, see you again.